Good evening. This is John Milburn for LAWS11057 Introduction to Law. This is week 4 of term 3, 2018. Today is Monday in week 4. That's significant because it's the day before what we call census. So if you are enrolled in the university subjects for the first time, you'll need to be aware of census date. I do hope that nobody wants to pull out of the unit, but I can say that if you do, you must try to do so before census date, to do so without academic or monetary penalty. If you go beyond census, then you need some special application in order to obtain some credit or refund, or so there's no effect on your academic record. So please keep that in mind. Now, we had a good question before we came on camera in relation to referencing. The AGLC is something that we use in the law school. Do try to get used to it immediately. Try to follow the referencing guide that you'll see in textbooks, case law, and other authoritative materials. So you can learn from viewing what others do, but importantly, have a look at the short reference guide to the AGLC. I fully acknowledge that you won't find everything there. For example, movies won't be there, or maybe books, novels, those sorts of things. But do try to identify the source of your material, irrespective of where it's from. Now, if you find that you just can't see an appropriate referencing style for whatever it is that you're considering, let's say a movie, then please ask through Q&A on the front page of Moodle, and let's all share some information. I may be able to assist, but others equally may have come across this problem and be able to assist. So just generally, if you have a problem, a question, whilst you might be tempted to immediately email me, it's certainly not my first preference. What I'd like you to do is ask through Q&A. We can share information. I may not be able to assist, but some of your colleagues may be able to do so. And whatever I contribute in that way is open for everyone to see. So that's a little bit on referencing, a little bit on Q&A. I now just want to talk about the assessment piece. So your first assessment is due on the 29th of November. I'm going to share the screen, and hopefully you can see the Moodle page. I have had some internet issues, so if you can't see the Moodle page, please let me know. But you'll see on the top left-hand corner the assessment item. And I will come back to that, but just firstly as a reminder, for those that haven't used the Q&A facility, here it is on the, I don't know if you can see where my cursor is, but Q&A there under Learning Outcomes, adjacent to where you joined the session that you've joined tonight. And if we look at Q&A, you'll see that someone will start a thread or a question, and people can reply to that. So Online Portfolio by Megan, thank you, 6 replies to that. And you'll see the last post there was from Lachlan. So thank you very much for those that are embracing this Q&A facility, and I encourage all of you to do so. Now, if we look at the assessment piece, and hopefully on your screen as I click different pages on Moodle, you'll see different pages. So just do you see the assessment item number 1 on your screen now? Has that come up, or is it frozen? It's come up, good. So what I'm going to do is just show you, peek at what I see on my screen, which will be different slightly to what you see. So as I pan down, you'll see the question, and that should be common to what you have, the various videos that we've provided for you to consider. And at the end of the assessment, you'll see at the bottom of the page, at least on mine, it says View All Submissions and Grade. So if I click those buttons, I then get to see what work you have uploaded into Moodle. So obviously yours will be a different looking page. I suspect there'll be a ribbon at the bottom which says something like Submit Your Work or Submissions. So is that correct? Is that what you've got at the bottom of your assessment? All right, yep, so thank you very much. Appreciate that. Now, you'll see that as we speak, with 3 days and 4 hours remaining before the work is to be submitted, that we have one student who has submitted their work. Kudos. I haven't checked who that is, but well done for submitting your work so early. 3 have submitted in draft form, and I don't mark draft papers, but if the papers remain in that draft format as at the time that the session comes to an end, then I will mark the draft as if it's a final. So please keep that in mind. I'd prefer that you submit as a formal or final paper rather than draft, but just keep that in mind. All right, so I'm just going to stop the share for a moment and ask if anyone has any questions about any of the things that we've discussed so far this evening. And I will get you to unmute your microphone if you wish to ask a question. Just have a look at the chat facility. Oh, lots of chat. That's good. And some tips there in terms of how to ensure that your work is presented well. Now, is there anyone who is really struggling with the assessment, the technology, any of the things that we need for you to consider? Yes, Mackenzie.
I have a question in regards to the online portfolio part. Are we just putting what we've done in the Word document portfolio online, basically all the same?
Pretty much, I think so, yes. So the idea is that you produce your online portfolio initially in a Word document, and then you transfer that information into the online format. Really what I'm interested in is what's online. That's really what I'm interested in. But I do tend to find that most students prepare a Word document so they've got it laid out and then they move it across. Does that make sense? Does that answer your question, Mackenzie?
And with the video that we have to put on YouTube, is that just a short video about like us and like that 50 to 100 words sort of thing?
Yeah, exactly. So it's a very short video. I think the maximum is 2 minutes. Probably most of you will have a video of 30 seconds, maybe a minute. You can talk about your portfolio. You can talk about yourself. You can talk about your ambitions, what you plan to do with your degree. It's really an opportunity to ensure that you've got the technology right, because in later units you need to upload videos as part of your assessment. So we just want to make sure in the first 4 weeks that you know how to do that. Then I'll be gauging the professionalism of your speaking voice, your content. So just a few things like that. But don't worry, it's not meant to be a difficult assessment. Does that answer the question, Mackenzie?
Surely does, thank you.
Great, thank you. Thank you for those questions. All right, are there any other questions, comments? Tuna, do you have anything that you wish to add? No? Thank you. Sorry, I had the microphone on mute. So thank you for your questions. Do remember the final assessment is due on the 29th. Please don't be late. If you are, don't panic too much. You'll lose 5% per day, but we would like to see you have all of your marks available to you for that assessment piece. All right, let's move on then. Now, has anyone looked at the Parliament of Australia website or the Queensland Parliament website? Just a quick yes, no, just to get you on the buzzers. Yes, yes, yes. Excellent. All right. Lots of people have done that. Has anyone come across info sheets in the Commonwealth Parliament? Yep. Good. I'm just going to share the screen for those that may not have seen those info sheets. They're a valuable resource, a quick reference guide, and you'll see there Commonwealth Parliament, House of Representatives, info sheets. It's a great place to start your research and something that you might want to incorporate in your toolkit, perhaps if it's of help to you. While we're still sharing the screen, and I hope this works, we have the Parliament of Australia Bills Digest section. is that what it shows on your screen? Bills Digest 1351998-99. Is that what it shows on your screen? Is that a yes? I'm just looking to see if someone, yep, right. Thank you, Gareth. So this is, for example, the Bills Digest created for the Environment Protection and Biodiversity Conservation Bill. You'll find this through the Parliament of Australia website. And the idea of this is that you will have detailed information about how the laws were created, background information that was relied upon by Parliament in creating the laws, and it refers not just to legal matters, but it might refer to external matters, scientific material, etc. So if you're looking to understand why legislation came into existence, looking at the Bills Digest could be a useful thing. Also, if you're arguing a case or you're writing a submission for a paper and you're arguing in favour of a particular interpretation, then referring to the material in the Bills Digest could be very useful. Let's have a look at the Queensland Parliament site. Again, most of you would have seen that. Thank you very much. You'll be aware that this is a place that you can find Hansard, and you can find bills by reference to that material as well. So the government websites are really useful, particularly at the start. And when you're looking at these websites, please do so actively. Don't just browse in a casual manner. Target your online research, because you'll come across something invariably that you think is particularly valuable. You think it's one of those things, oh, I must remember that. Now, if you have that thought, oh, I must remember that, that could be useful at some stage, what I'd like you to do is catalogue it. Catalogue it into your toolkit, which is the second assessment piece. And it's got to be something that makes sense to you. You won't be able to catalogue it unless you've got the skeleton, the template, or the framework for your second assessment piece. So I'd encourage you to do that now, as soon as you've finished your first assessment. So do you understand what I mean by this active research, online browsing that is targeted, so that you're building something as a reference point for yourself in terms of online materials? All good? Okay, now we know that a bill is a draft act. Not all bills become acts, but all acts will start life as a bill. A bill comes into law after it's been through Parliament, both houses in the Commonwealth level, one house in the Queensland level, and then it's received its assent by the Governor-General. So we know all that, don't we? When you're referring to an act, capitalise the word act, so it's capital A. When you're referring to a bill, don't capitalise that, the word bill. Make sure that you're aware of the procedure for creation of an act, how a bill becomes law, and catalogue that into your toolkit. Make sure that you know how to access second reading speeches, explanatory notes, or explanatory memorandum. That's very important. And make sure, if you don't know already, how to find point-in-time versions of legislation. Now, those that are doing statutory interpretation or have done statutory interpretation will find this an easier task. But can I just ask, as a general quick guide, do people know how to find the version of a legislation now, and in addition to that, a version of the legislation at a point in time, say 2012, 1st of January 2012? We're getting a few no's there. I think we've got a couple of yeses, a few no's, a bit of a mixture. You would really like me, I guess, to show you the answer, but I'm not going to do that. So what I want you to do is, as part of your homework for this week, informal homework, find out how to access the point-in-time versions of legislation. If you have problems, please just don't be afraid. Don't be concerned. Just say on Q&A, I need a hand. Don't know how to do it. Someone may say, I've got a great way of doing it. We're going to try and help each other through this unit. So maybe someone will give you a link or perhaps a screenshot to assist. And of course, I might be able to help as well. All right, so we all need to know that. Can anyone tell me why we would possibly need to access point-in-time versions of legislation? Surely we need the current version, don't we? Or do we? Why would we need to access past versions of legislation? A few answers coming through quickly. Does it apply to history? Sandra's got the answer I'm after. Thank you, Sandra. Take into account when a matter occurred. Peter's described it this way: arguing a case from the past that an act has been updated since. And Benjamin, to see what changes have taken place since then. If, for example, you're acting for someone who's prosecuted in relation to a matter that occurred in 2011, then you need to access the legislation as it was at that time, because there's a basic tenet of our law that legislation does not operate retrospectively. Otherwise, those things that might be illegal now, but not illegal in 2012, would have a great injustice, wouldn't we? People being prosecuted for things which were perfectly legal at the time. To a lesser degree, a less dramatic degree, is this: if someone is being charged with a criminal offence allegedly occurring on the 1st of January 2012, it may be that the penalties for that offence at that time were far less severe than they are now. So legislation changes, the penalty regime changes, and all of that should be taken into account. But in order to do that, you need to have a look at the historical version of the Act. All right, so by next week, everyone will know how to access legislation, bills, understand the process, find point-in-time pieces of legislation, understand and find where they can find second reading speeches, explanatory notes, and, as we've discussed tonight, through the Bills Digest, we'll be able to find information regarding research publications. And this is valuable in terms of providing the background. All right, if you have trouble finding any of those things, please ask through Q&A, and collectively we can have a look at that. Do have a look at the federal level, the Australian Parliamentary website. The Education Office, Parliamentary Education Office, is an excellent resource. Just in case you haven't looked at it, I'll bring it up on the screen now. And it's very well laid out and gives a lot of useful information. So there it is, the Parliamentary Education Office, which you'll find on the Commonwealth Parliament of Australia website under the ribbon About Parliament. Okay, I know I'm moving quickly, but I hope that it's all going well. No questions so far? Good. Queensland Parliament has its own similar types of information online, so I'd like you to be very thoroughly conversant with the parliamentary websites, the process, and proceed from there. Now, we have talked about delegated legislation, haven't we? Does everyone know what I mean by delegated legislation? Just a yes or no? If you had to describe it for me, not that I'm going to pick on you, but if you had to describe delegated legislation, we're getting mostly yeses, a few nos. So again, if you don't know what delegated legislation is, how it comes into existence, why it's used, then please do some research during the week. Would anyone like to, I'm not going to pick on anyone, but would anyone like to just explain what is delegated legislation and why it exists? Any takers? No? All right. So, Peter says, legislation that an Act gave to a government department? Essentially, yes. So Parliament is conferred with power under the Constitution to make laws. The executive, government departments, have no such power, but in order for Parliament to save time, to keep up to date more readily, and to deal with issues to do with compliance, Parliament can delegate the power to make certain pieces of legislation, such as regulations, rules, ordinances, bylaws, to the executive, which are really government departments, if you like. So that's why we have these regulations or ordinances or bylaws, and it filters down to council level, below state level. All right, if you don't understand that, do a little bit of research, find a commentary or a website that works well for you, and catalog it into your toolkit, so that in your toolkit you may have a link to delegated legislation or some information that works for you. All good? All right. Instruments handbook, really useful. This is an example of what I mean by an instruments handbook. I'll share the screen. I'm very conscious that I'm loading you up with homework tonight, but this is all, if you can understand, if you can all appreciate, this is all very useful for your toolkit for the second assessment. So here we have the Australian Government Office of Parliamentary Counsel Legislative Handbooks, and we have the Instruments Handbook. I would urge you to look at that, perhaps even download it. It provides information to help Commonwealth rule makers and agencies make and manage legislative and notifiable instruments. It's a good publication. So it provides key concepts, including the Federal Register of Legislation. You're probably familiar with that already. The drafting and interpretation of instruments. This will be useful if you're dealing with statutory interpretation issues. The procedure before and after making legislative instruments, explanatory statements, parliamentary scrutiny of instruments, and as you can see also sunsetting. All right, so that's the legislative handbook. That version is the Commonwealth version, and I'd urge you to access that. Have a browse through it. You won't be able to read it all, but somehow keep it up your sleeve when you need to refer to an authoritative source quickly. Now, the Crown. Does anyone, Matthew's seen it, so thank you, Matthew, that's good. Now, can anyone tell me what the Crown is? I think we touched on this maybe last week. The state, like a hat. I'm not sure about that one. The government, the Queen. We're pretty close. We're pretty close. The governing body, says Tuna. Yep. All right, so when you're doing your toolkit, I think you need to have a clear statement of some of these terms. Otherwise, there's a risk of a lack of precision and everything is just government. Now, last week we talked about government at different levels in terms of government through Parliament, government through government departments, the executive, government through the courts, but also government is structured by way of federal, state and local council. So there's different ways of describing or looking at these institutions. So you'll need to have something which tells you very quickly and precisely, probably in your toolkit, but it doesn't have to be. It could be a link even. What do we mean by government? What do we mean by Parliament? What do we mean by the executive? What do we mean by the Crown? And then there's some easy ones like, what do we mean by the judiciary? And you then got to start to think about where all of this ties in. So governments come and go, don't they? We have an election, governments come and go. but the Crown is always there. So the Crown's an institution in Australian law, and all land, natural resources in Australia, subject to native title, of course, derive from the Crown. So title to land and resources that have not been transferred to private ownership remain with the Crown, not the government, because governments come and go, but it remains with the Crown. Look, I think someone said it's the state. Yep, so if we're in a non-monarchy arrangement, then it might be described as the state or the people, you know, to take the American version. So the Crown is not the government, but the government is responsible for the affairs of the Crown. So sometimes you'll hear of legislation being expressed to bind the Crown. This means that the institutions of government must comply with the legislation. I mean, the best analogy I can come up with is household, that people living, family members who live in the house might come and go. You know, the people leave, they go away, they come back. So they're members of the household. So the Crown is like the household. It's sort of that institution that's always there, and the individuals might come and go. Does that make sense? It's the best I could come up with. So that's the Crown. Come up with your own definition and your own way of interpreting or describing what these things mean. Now, case law, doctrine of precedent. Oh, this is, Tuna says, the invisible hand that controls governing body. Oh, I like that. That's inventive description. All right, now case law. Doctrine of precedent. It's not doctrine of precedence, it's the doctrine of precedent. So what does that mean? In general terms, if a court has decided a matter one day, then you'd think that people would be able to rely upon that as the way in which the court would decide the same facts the next day. Otherwise, it becomes very confusing, doesn't it? So that's the general idea of the doctrine of precedent and case law. But, very importantly, a hierarchy exists. Hierarchy applies. So if a magistrate makes a decision in relation to a set of facts, that is applying the law, but the district court does not have to be, is not bound by that decision of a magistrate. However, the district court is bound by a decision of the Court of Appeal or the High Court. Does that make sense? So in order to understand this doctrine of precedent, you first need to have a clear understanding of the court hierarchy, and then within that have some qualifications. So if a Supreme Court judge decides on a certain set of facts last week, does another Supreme Court judge have to follow what his or her colleague had decided the week before? The answer is no. So when we talk about precedent and the hierarchy, you've got to be clear about where it applies. Now, I think I've got a note here that figure 5.5, there's a flow chart in your textbook. It might be an old reference, but can anyone tell me if they can see the flow charts, or if they come across flow charts for both the federal system and the state and territory systems? Ah, there you go. Thank you, Matthew. What page is that, Matthew?
171.
171. Is that for the federal jurisdiction?
Yes.
Federal, yep. Okay. Have they updated it? Is it still the Federal Magistrates Court, or does it say the Federal Circuit Court?
Federal Circuit Court.
Right, okay, well that's good. I mean, that's going to change very shortly again, but excellent. And the state system, can anyone tell me where that is? Page 174. Thank you, Abby. All right, now there's a question about persuasive context Yes, Gareth, that's a really good point. You're right. And you're probably referring to my comment about Supreme Court judges. Absolutely. It's very persuasive. It's highly persuasive, as is decisions of, say, the Supreme Court interstate. Technically not binding on courts in Queensland, but highly persuasive. All right, and this is where you need to have an idea of how these things fit in. Okay, cases that are reported or unreported, what do we mean by that? You might hear reference to a reported decision or an unreported decision. Any ideas? Many cases are heard in Queensland and Australia every day. Almost all of them are not reported in a public forum. Some of them are, but not all of them. So magistrates, Gareth says, is unreported. That's almost always incorrect, but not always. Some magistrates' court decisions are actually reported. Not too many, but some. Court of Appeal decisions are almost always going to be in some way reported, but and the High Court will always be reported. So some are reported, some are not. Some are authorised decisions. Some are in an authorised report, some are in an unauthorised report. So you need to find somewhere that has the list of what are the authorised reports. So for the High Court, for example, the CLR. And where to find them. Now, I've done some videos on legal research. If you haven't already looked at those, now's a really good time to do it, because you'll need all of that, I think, in preparing information for your toolkit. And these are the sorts of things that you might want to pop in. Monetary limits. You'll need to have a good idea of this. Can anyone tell me the monetary limit for the Supreme Court in Queensland? You're doing well. I know I'm moving fast. Monetary limit, Supreme Court, Queensland. Gareth says from 250. We have a vote for 750. I don't know if you saw Austin Powers, but at one stage they wanted to hold people ransom for, I don't know, $1 trillion billion or something. You know, what if you're suing for $1 trillion billion? Where would you go? Which court? All right, so the Supreme Court is unlimited. There's no limit, upper limit for the Supreme Court. District Court, what's the upper limit? 750. Very good, thank you. Upper limit for the Magistrates Court? 150. Excellent, thank you very much. Tricky one, this is a trick question. QCAT, what's the upper limit? We're getting some different votes. 25, 25, 150. The reason it's a trick question is in QCAT there are there's a basic division. There's what they call the minor civil disputes jurisdiction, which is the old small claims tribunal. So QCAT is an amalgam of, I don't know, 30 different tribunals. So one of them was the old small claims tribunal. So we now call them minor civil disputes, things like small debts, motor vehicle accidents, landlord-tenant disputes, that sort of stuff. In the MCD jurisdiction of QCAT, it is indeed $25,000. It might be increased soon, but it's 25. Other than that, it is essentially unlimited in QCAT, with some exceptions. For example, if you have a dispute about a retail shop lease, then the jurisdictional limit for the tribunal is $750,000. So what you can see is that when Parliament creates laws, it not only creates the substantive law, as we call it, but it also creates some procedural law. And part of that procedural law indicates in some circumstances where certain disputes are heard. before what court or tribunal the matters are heard. So you can't, for example, take a dispute about a retail shop lease to the district court, even if the amount that you're arguing about is $500,000. Under the Act, the procedural provisions say that dispute goes to the QCAT for $500,000. Does that make sense? So when you're looking at legislation, always be mindful of, are there any provisions that dictate where you should take the matter? Okay, let's keep moving on. Adversarial versus inquisitorial. Has anyone seen that distinction? And in Australia, what do we have? Adversarial or inquisitorial or both? You can answer with A or I or B or both. Tim says both. B, B, A. It's a bit of a trick question because most people would say A, we have adversarial, but we also have inquisitorial, depending on the nature of the tribunal and the nature of the evidence. So if, for example, in the Supreme Court, it's always going to be adversarial. So for the mainstream courts, if you like, it's primarily, if not exclusively, adversarial. But when we deal with tribunals in particular, it tends to be inquisitorial. Inquisitorial is, Royal Commission is inquisitorial. Yep, that's a good contribution. Inquisitorial comes from the civil law countries. So Australia is what we call a common law country, as opposed to civil law countries, such as, I think, France. So in civil law countries, we don't really have the doctrine of precedent, and we have inquisitorial process rather than adversarial. Family court proceedings might tend to be a little inquisitorial. So different jurisdictions have different ways of going about gathering and dealing with evidence. But there is that basic distinction between that which is adversarial and that which is inquisitorial. And I hope I'm not confusing you too much. But again, if you're thinking about your toolkit and you're thinking about how you would go about advising clients in relation to a dispute matter, you've really got to have this sort of stuff nailed, don't you? You've really got to be able to say, okay, this is where I would take this dispute. This is where I would consider. You don't have to have an answer on every possible dispute, but just be aware of it and build it into your thought process so that it's part of your flow chart. If you're answering a question during your law degree, you need to go through that same process, don't you? I hope that makes sense. Any questions before I move on? All good? Okay, you're doing well, you're hanging in there, you're staying with me. So, next thing, addressing the judiciary. I think we dealt with this last time. In court, Your Honour. Out of court, socially, carefully, maybe judge, but not the Chief Justice. That would be Chief Justice and likewise the Chief Judge. Magistrates, in court, Your Honour. Out of court, generally Mr. or Mrs. And tribunal members, in court member, if not just Mr. or Mrs. or Ms. Okay, all good? So let's move on to legal thinking skills, which is really the topic for this week's material. But first, a brief introduction to community legal centres. Has anyone linked to a community legal centre, a CLC, or been to one? If you've got time, and I know you're all very busy, but if you've got time, there are 33, I think, independent legal community centres around Queensland. Have one via work. Yes, says Gina. Good. So good on you, Mackenzie, for doing that as well. If you can link with a community legal centre, you might find that there's some valuable information, some opportunities to engage. If you've got time to do it, it would be worthwhile. All right. Now, as I mentioned, we're on to legal thinking skills. Here's where I think you need to adopt a broad approach, and that is in the sense of not necessarily answering every legal question with a legal answer. It sounds a bit vague. If someone comes to you with a problem, then going to court is not necessarily going to be the best result for them or the best course of action. When I studied law, that was the only place that people would go. But can anyone think of where you might consider referring a client or recommending a client deal with a dispute matter other than simply going to a court or a tribunal? Sandra's onto it. Mediation. Settlements. Any others? Mediation. Ombudsman. Yes, mediation. So there are a range of different places that one can take a dispute or deal with a dispute. It doesn't have to be the courts. So again, I would have thought that would be useful for your toolkit, so that you're thinking about laterally how to deal with legal problems. And it's all part of legal logic. All right. At this stage, I would normally talk about the IRAC method, MIRAC, CIRAC, but we talked about that a few weeks ago. So I'm going to move on from that. Deductive reasoning. Did everyone have fun reading this chapter of the text? Deductive reasoning. A lot of it's intuitive, but can I say this? You won't actually use it. Put you to sleep. We've got a few answers, yeah. A few answers, no, it's pretty dull. You won't actually use this overtly, but you will use it as part of your legal reasoning. So what we're doing in this chapter, probably for the only time during your law degree, is saying, here's the way that lawyers think. And there's a lot of logic in it. I don't know if people have studied logic, but so let's go through the first one. For example, it's this. Deductive reasoning, you state a proposition, you make a statement of fact, and then you draw a logical or legal conclusion. So what's a statement of a proposition? All x's, see if you can follow me with this. All x's are y's. You with me? This z is an x. Therefore, this z is a, what's the answer? Is a y. Exactly. Thank you. So that's deductive reasoning. And it's kind of common sense, isn't it? But you might want to use those sorts of things in making arguments or answering problems. So deductive reasoning is, you won't actually have a chapter heading says deductive reasoning, but you will use it. So I want you to think about that as a way of answering legal problems or looking at legal problems and giving it a bit of structure. Inductive reasoning means predictions based on experience. Where would you use that? Well, inductive reasoning might be relevant if you are arguing that someone should be on probation rather than go to jail because some experience says that people that go to jail might end up liaising with criminals. So that's maybe not the way that the court wants to go. Reasoning by analogy. Reasoning by analogy suggests that one thing will have the characteristics of another thing, but you do need to be careful here because this can easily become faulty reasoning, which we describe as reverse accident or hasty generalization. So reasoning by analogy has its place, but you can easily fall into error. I hope that makes sense. Faulty reasoning, sweeping generalizations. Now, the key to this is, and this is where you might use sweeping generalizations, the logic behind it, as a means of attacking an opponent's argument. So if the main premise is overstated, the conclusions drawn will be invalid. So if you're attacking an opponent's argument, you might argue that the initial premises or the main premise is overstated. Hasty generalization. Hasty generalization is not enough evidence. It's a little bit like Brigginshaw, but hasty generalization, there's just not enough evidence to go on. You've come to a conclusion too quickly, too hastily. Now contrast that to inductive reasoning because it looks similar. And if this is starting to get confusing, go back and reread the chapter. Attacking the person. Just because a bad person has a trait or characteristic, that does not necessarily mean that a bad person will always have a certain trait or characteristic. Appeal to authority. This is the opposite of attacking the person. So what a well-credentialed person says is not necessarily true. This is important for lawyers to understand because part of your role as lawyers, this is part of your obligation, is to question. And if you have to question authority, you question authority. Lawyers are at the vanguard of ensuring that justice is done. We are tied up with the judiciary. Our primary role is to ensure that we are brave enough to make appropriate challenges when need be, when it's warranted. Do you understand? This is really important part of being a lawyer. So in terms of how we think about that, from a logic perspective, it is the appeal to authority. So what a well-credentialed person says is not necessarily true. So as a lawyer, you've got to say, well, okay, this is a person with authority making a statement, but I am duty-bound to question that. So in fact, it's okay to question what's said. Now, lawyers do it all the time. In the High Court, we have a decision of 4-3 in the High Court. So again, people are questioning themselves, each other, in that context. Appeal to majority is just because most people think it is so, does not make it so. Again, as lawyers, you have this obligation to ensure that you do not automatically go with what everyone else says, but you stand firm and you have that independence of thought. Straw man argument means the practice of unfairly misrepresenting or exaggerating your opponent's claims. Irrational correlation or causation. Here's an example. During the last 100 years, we have seen less pirates and more global warming. Therefore, global warming is caused by a reduction in the number of pirates. You see what I mean? So that's irrational correlation or causation. And you won't actually say these things, but you've got to ingrain them a bit into your psyche so that when you read something, you're challenging it. You're saying, that's not quite right. The premise is wrong. You have made a correlation that's not entirely correct or justified. It's illogical thinking. So it's all part of critical thinking as a lawyer. To be a critical thinker, you must be reasonable. You simply can't just criticize, you have to make informed criticism. But you are duty-bound to be critical in your thinking as a lawyer. Ask yourself whether the argument that you hear is reasonable. Ask yourself, is it based on reliable information? Is it based on a valid assumption? Does the argument contain validity? Is your argument, if you're making the argument, ask yourself from a critical thinking perspective, am I basing this argument in a manner that is consistent with primary sources of law? Now, you may rely upon what you've read in a secondary source of law, but always the main argument has to relate to primary sources of law, legislation, case law. Can your argument be supported objectively based on fairness or justice? So this is where you might bring in extrinsic material, empirical evidence, well-informed opinion of experts. So in the textbook, there's another quote that I particularly like, and it says, critical thinking is an act of thoughtful disobedience rather than thoughtless or automatic disobedience. You see the difference? So as lawyers, you have this role to think critically. Therefore, critical thinking is an act of thoughtful disobedience potentially. Don't be disobedient just for the sake of it, but challenge things. All right, thinking skills. This is relevant when it comes to an examination because you need to consider the first word of the exam question. The question might say, interpret something, analyze something, evaluate something, explain something. You need to understand what those words mean, because if your examiner asks you to draw inferences, then the examiner is not asking you to provide an explanation. The examiner is asking you, or is testing your ability to draw conclusions from what you've read, rather than just explain it. If your examiner asks you to analyze something, as opposed to interpret, you need to understand the difference. So analyzing means the ability to identify hidden features, amongst other things. Whereas interpreting means the ability to determine the material matters. Now there's a big overlap, I appreciate that, but I'd really like you as part of your toolkit to have something that works for you so that you understand what these words mean, so that when you read a question, which you will read all through your, you'll have questions like this all the way through your studies, you've got an idea of what it is that the examiner is technically asking you to do. All good? Okay. Attributes of legal practitioners. How do you improve on your skills in these areas? And this is in the textbook. So, what makes a good legal practitioner? You need to be inquisitive, alert, self-confident, open-minded, flexible, fair-minded, honest, prudent, diligent, and persistent. I won't examine you on this, but I'd ask that you please look at that list and ask yourself questions about where am I strong relative to those attributes? Where am I not so strong? And if you're not so strong, how do I go about improving that? Even if you're not going to practice as a lawyer, even if you're doing introduction to law as part of a different degree and you're just dipping your toes into law for a bit, these are things that might help you generally anyway. And that then brings us to the end of week number 4. So are there any questions that anyone has about any of the content that we've covered tonight? You've been very patient listening to me. I appreciate that. Any questions, comments? All good? All right. Good luck with your first assessment. Don't stress too much. It's a really easy assessment. I just want you to really get the technology. Make sure that you can present in a professional manner your material. Look at the guide to legal citations and work from there. And now start in earnest working on your toolkit for the second assessment. All good? All right, we'll wrap it up there. We'll see you next week. Actually, now we will not see you next week. That's correct, isn't it? Next week's the university break. That is correct? All right. Well, that being the case, we will see you in 2 weeks tonight. So all the best, and we'll see you then. Bye.